Well, I was about to assign all blame to you, Wayne, but I'll refrain. Jim Mount, we had a lovely trial once where I stole some of his rhetoric before the jury. One thing that I remember about what Jim said, during voir dire, some juror was given kind of an equivocal answer. He wasn't sure, whatever. And Jim said, well, that's like a knife in the heart to a lawyer because you couldn't take a stand. And I've stolen that on several trials, and so it's good to see you here, Jim. I've enjoyed practicing in Harris County because we get to go to trial periodically and share our views with our other fellow citizens. I see trial, it's in a way coming and speaking to you in regard to closing argument is a little bit difficult. It's hard to make an argument out of the context of the facts. Normally, when you're making a final argument, you're talking to people who've heard all the facts. Out of context, it's kind of difficult. I see trials kind of in an Aristotelian way, harkening back to my undergraduate days. Aristotle said that all drama should have three parts: a beginning, a middle, and an end. Thank you, Aristotle. The three parts of the trial that I see, the beginning of it is voir dire and opening statement. The middle is the evidence itself, and the end is the court's charge and the charge wars that goes on between the lawyers and the judge, the argument, the juror's notes, and finally the verdict. These are the three, in my view, the three parts of trial. Of course, we don't want to go to the fourth part of trial, which is punishment, but we'll talk about that as well. The court's charge essentially is like a blueprint for your case, in my opinion. You should be able to have some sort of idea of what issues are coming up and be able to look up the court's, what you anticipate the court's charge is going to be, and use that. It will have rhetoric that you can use and you can inject throughout the trial. In recent years, I've heard about this phenomenon called looping. I was doing looping before I understood that it was looping, and Wayne was instrumental in guiding me in that many years ago. That's where you use certain rhetoric throughout the trial. For instance, if someone on the jury makes some kind of statement on the veneer panel, makes a statement that's somewhat memorable, if you can, you inject that into your final argument if they make it onto the jury. This makes the juror feel good and knows that you're listening to him. That's an example. The other thing is that I try to have the jury focus on three great principles of American jurisprudence because they come into play in virtually every criminal case, and they are helpful to the defense. In many respects, the only thing really helpful to the defense is the Bill of Rights in the U.S. Constitution, and that gets back to the fact that our forefathers at the get-go of our country were outlaws. And had we lost the war, the British would have treated them the way the lead character in Braveheart was treated at the end of that movie, if you recollect, where he was drawn and quartered. This has a tendency to focus the mind, and as a result, we have the strongest Constitution, I think, on the face of the earth. And the three great principles that I try to hearken back through, both in voir dire and then later in final argument, is first, presumption of innocence. Okay, we all know about that, but a lot of our fellow citizens are surprised to learn that we start off with the presumption of innocence. And then the burden on the state, and then that proof beyond a reasonable doubt, and to show the different layers of types of proof, and to show them how reasonable doubt is such a heavy burden for the state. And try to inject that same rhetoric, which is going to be in the charge in all criminal cases, in your argument to the jury at the end of the show. You got to hope for the best, but you got to prepare for the worst. You got to bear in mind of where we are. We're in Harris County, Texas. And this is a pretty red county. And the people that show up for jury duty are by and large people that watch Fox News. And their whole perspective has been propagandized, in my opinion, by the far right wing of the Republican Party. And with some exceptions, like the last judge that just spoke, most of our judiciary here have only been on one side, on the DA's office. And then they're elevated to the bench, and they never represented a human being. And so you're up against the wall with the judiciary in this county. Makes it tough. We have a very fine DA's office, in my opinion. They do a good job at trial, and they're formidable, and you better be ready. The mantra that goes through my head is what was taught to me by Don Lambright, another lawyer who's probably been practicing 50 years. His theory is you make fear your friend at all times. Bearing in mind that the hunted animal is never bored, and that's who you are, because they're out to get you. Actually out to get your client, but they're out to get you on their way to getting the client. And the people that show up for jury duty, bear in mind, they're not showing up to cut somebody loose. They're showing up to be able to go back, once they hear they're on a criminal panel, they want to go back to their friends and neighbors and say what tough guys they are. And if they took one of them off the street, what they don't want to do is say, well, we had a reasonable doubt, we're kind of wishy-washy, we put him back on there, I don't know, if he does it again, maybe they'll catch him and have better evidence. They don't want to do that. They want to go back and say what tough guys they are, and they put one off the street, specifically your client. So bear that in mind throughout the entire proceedings, that they are very, just like the judge said, they're very skeptical of you. You're the defense attorney. You've got to deal with years of propaganda that these people have heard about how we're, not to be trusted. And so you've got to work against that, and you have to be aware of it in order to be able to work against it. One thing, when I was a prosecutor in Judge Poe's court, he did teach me one thing, well, many things, but one thing was speak loud. Speak loud, or they can't hear you. And if you mumble or you don't speak loud, if you don't speak in a stage voice, then they begin to think, well, you don't really believe in your case. Because these people have been watching Fox News, and what's on Fox News? People yelling. People passionate. You got to be passionate. You got to be, if you don't, or at least act like you are. You got to convey that to them, or else they're not going to think you're serious. Because what they really, really want to hear from defense counsel, in my opinion, is some kind of telegraph to them that, hey, this is show business. I'm in it for the money. We got to go through the motions. It's show business. So if you give them any hint of that, it's like blood in the water. So I urge you to be as passionate as you can, because they equate passion with conviction. It's not always the case, but that is, I believe, the way so many of our fellow citizens think. You got to look at jury service as a political act. That they're down here to clean up the county. And that whole perspective goes against the defense. So you start off with that. The only antidote you got is the words on paper from the Bill of Rights that are contained in the court's charge: presumption of innocence, burden on the state, proof beyond a reasonable doubt. You gotta go over that with them a lot, in my opinion. One thing about reasonable doubt that I do in terms of this looping thing, sometimes if I can get away with it, is I'll try to inject a kind of a definition that reasonable doubt consists of things that make you go, And then, if something happens in the trial, which is a little helpful to the defense or unusual, defense counsel might go, You might do that in the final argument as well. I urge you to think about that as a technique. Sometimes it has resonance with the jury. In terms of time, because how the trial progresses will be determined by the judge to some measure in terms of how much time they give you. What I would urge you to consider is that you want as much time as the court will allow, or even beyond that, for voir dire. You want as much time as they can give you for opening statement. You want short argument, in my opinion. You want short argument because you don't get the last word. Tactically, argument is better for the state than it is for the defense because they get to open and close. So if the state wants 20 minutes to argue, I want 10. And usually the judges, that's one thing they're okay with, keeping it short. You need to be succinct and get to the point of your argument, in my opinion. And by the way, it's just my opinion. There are many lawyers in this room right now that are very fine practitioners, and I would defer to them on any occasion. Mr. Cunningham, for instance. And so these are just things I believe about closing argument. I also think closing argument or final argument is appreciated for the most part by the lawyers who are rattling on, because I have been on the jury. And generally speaking, I think that jurors have pretty much made up their mind by the close of the evidence. Hell, I think a lot of them have made up their minds by the close at the close of opening. The critical part of the trial is voir dire and opening, in my opinion. If I were a prosecutor, I don't think I would ever open. Because if the prosecutor opens, it means the defense can rise to the occasion and give their interpretation of what they anticipate the evidence is going to show. If the prosecutor decides not to do that, well, then it's highly unlikely that the court is going to allow defense counsel to give an opening if the state doesn't. It's within the discretion of the court. But generally speaking, what happens is the court will say, well, you can give your opening when you open your case. Well, by that time, cat's out of the bag. It doesn't have the impact that it has at the beginning. To me, opening, if you can give an opening statement, you can get more mileage out of that than you can out of final argument. Because the jury has heard the evidence. Whereas with opening, they don't know what's going on. And you can badmouth the state's case, at least, in any opening statement, and challenge the credibility and open the jury up to skepticism with an opening statement. And so I urge never waive opening if you can possibly avoid it. I know there's always exceptions because of surprise. We want to surprise the other side. Although I personally think, in things I believe, that surprise is overrated. That if you hit them with a hard opening, that's when you hit them with then they're surprised, then they're rattled, and they have a hard time responding in some cases. So anyway, those are my thoughts. Also, the trial begins the minute the panel enters the room, the voir dire panel. These are pretty elementary stuff, but I mean, your client needs to dress properly for trial. And if you don't tell them to do that, they're liable to show up, looking every inch the villain. I had a client one time years and years ago where I failed to properly admonish him. He showed up all in black. It was a good look for the jury. And then you clue them in about body language, about sitting up straight, acting like they're interested in what's going on. And sometimes you can give them something to do by giving them a notepad to take notes on, and to confer with you and to assist in their defense. And sometimes they can. I think you got to bear in mind that once you get that 12 in the box in the jury, somebody is seeing something all the time. It's like a 12-headed monster. in a district court, or a six-headed monster in county court. At least one of them is watching you at all times. You are on stage, you are under the gun. And again, what they're really looking for is something that'll telegraph to them that it's okay, it's just show business, we have to go through this. The state, the prosecutor, has built-in credibility. We have to earn our credibility at trial with the jury. Again, things I believe. You need to be succinct. You need to focus obviously on the weaknesses of the state's case. One danger of final argument, and you've got to be careful with, is not to open the door, not to make some kind of comment that will to invite argument by the other side, because you always got to bear in mind that it is the prosecution that gets the last word. So be careful about that, because if you say the wrong thing, then they can get up and respond to it, whether it's in the record or not. So, and typically the courts let them do it. Once you sit down from final argument, what usually happens in the trials, the state a lot of times doesn't do a whole lot of objecting, I've found, in final argument, because they want to kind of set the precedent for the defense not to be objecting to them when they get up and give their argument, and they're focused kind of on their argument. So it just seems to me like they don't do a whole lot of objecting. The defense should object at every opportunity, in my opinion, in final argument to the state's case. But you have to do it in good faith, and there has to be a basis for it. But don't be reluctant to do it. Don't be reluctant, in my opinion, to stand up and give a speaking objection and throw them off, because they're going to get the last word. And if they talk about anything outside the record, get up and object.